Good afternoon, members of the subcommittee. The clerk will open the roll, and members will indicate their presence. Clerk will close the roll. A quorum is present. Again, welcome to the final episode, is that the right word? Meeting of the General Laws Housing Subcommittee before crossover. We've got a fairly busy docket today. We'll move through with all deliberate speed, but also want to make sure that there are some issues where people are here to be heard and make sure that everybody gets an opportunity to get their say. I've got Delegate Kilgore, I see sitting in the front row. You have, I think, is a pretty easy one. It's famous last words. Delegate Kilgore, do you want to go ahead and do House Bill 2210?
Thank you, Mr. Chairman. House Bill 2210 is brought to me by the Virginia Realtors, and it seeks to increase the amount of time real estate experience required to sit as a real estate licensee member of the real estate board. It increases it from 5 to 10, and you might ask why.
Why?
The reason why is because it is a working committee on the real estate board. That board really works hard. They are responsible for regular meetings throughout the year, reviewing every educational instructor and every course in its full curriculum, and also all kinds of other issues. So it's and a lot of times, when you have just someone who has 5 years experience, maybe they only do 2 a year, 2 closings a year or something like that. So it's important that we get the right folks, the experienced folks on there. So we hope that you will pass this bill.
All right, any questions from members of the subcommittee? Anyone in the audience wishing to speak in favor of the bill, please come forward.
Thank you, Mr. Chair. Erin Corman with the Realtors. We just want to thank the patron for bringing this bill. We hope it's going to increase the quality of candidates on the real estate board, and we ask that you support it.
All right. Anyone else? Anyone wishing to speak in opposition to the bill? Seeing none, the committee operates by motion.
Move to report.
Second. Moved by everyone to report and seconded by everyone to report. The clerk will open the roll. What a popular bill.
Thank you.
The clerk will close the roll. Bill reports by a vote of 7-0. Thank you. All right, who wants to follow that? Delegate Laura Jane Cohen. She's like, no.
Let's just make it 2 in a row, guys. Thank you, Mr. Chair, members of the committee. I have HB 1680, which amends the definition of place of public accommodation to include a website that a private entity owns, leases, or operates, and whose operations affect commerce. The Americans with Disabilities Act prohibits discrimination against people with disabilities in all areas of public life. The ADA requires that all organizations must comply with the accessibility standards included in the Act. And the U.S. Department of Justice has consistently taken the position that the ADA's requirements apply to websites. This legislation would bring the Code of Virginia into alignment with federal law on this issue. This bill comes directly from the Disability Law Center, and I know they're here to speak to it. Thank you so much.
All right. Any questions from members of the subcommittee? All right. Anyone wishing to speak in favor of the bill, come forward.
Mr. Chair, members of the committee, John Smee with the Disability Law Center of Virginia. We firmly support the bill. Website accessibility is really important today and are increasingly so in our world. And as mentioned, it's already required by the Americans with Disabilities Act that most websites be accessible, and we think it's wise to make Virginia law consistent with that.
Thank you. Anyone else?
Mr. Chair, members of the committee, Jen Kraski with the Virginia Board for People with Disabilities, and we support this bill.
All right. Anyone here wishing to speak in opposition to the bill, please come forward. All right. Nobody wants to speak up against this bill. Delegate Cohen, I have some concerns about the scope of the bill. I think that I understand what you're trying to do. And I think it's well intentioned. I think that we probably ought to do that, but the sort of blunt instrument, right? So on line 36, we just add or website to a place of public accommodation. And I'm not sure that the way that that's drafted, we fully understand all the possible implications of that. And every website, everywhere is a public facility. And so I would hope that we could actually get a little more work on this issue. And I think that some folks that understand, because there's I understand that under the ADA and website compatibility, there's a certain technical standard and protocol and so forth that's supposed to meet, and I don't pretend to understand how that all works, but I think we could accomplish some what you're doing, maybe working through that, but I don't know that this bill's the best way to do it. And so I think we talked about this before, but you might be amenable if we were to send this to the Joint Committee on Technology and Science, I think Jay Cotts, with a letter from the chairman, let them look at the offseason and say, hey, is there a better way to accomplish what you're trying to achieve than just adding or website in the public accommodation statute? And so with that, I would entertain a motion. Delegate Price.
Before we get to a motion, I had a comment, Mr. Chair.
Delegate Price.
Is it possible in that letter for them to be asked to expedite this? Because I think this is an issue that we've heard several years in a row, and the further we kick down the can, I think the further we create disparities in the disability community for being able to do their business as well.
Yeah, I think I see Mr. Chairman is here, who's going to be the author of the letter, and I think that probably asking them to do this before, in time for us to get something in prior to the pre-filing deadline for 2026 is a reasonable ask. All right. All right, so is there a motion?
So moved.
Move to lay it on the table and send a letter to Jay Cotts.
All right. It's been moved and properly seconded that we lay this bill very gently on the table. The letter to Jay Cotts and ask them to quickly take a look at the best way to accomplish this and achieve the goals of the legislation. The clerk will open the roll. Clerk will close the roll. Bill is laid gently on the table. Thank you, Delegate Cohen. Thank you for bringing this and your work on this issue.
Thank you.
All right. Delegate Sewell, you're next on my list and you're here. I won't comment on whether this can be an easy one or a hard one. We'll see.
Sounds good. Well, thank you, Mr. Chair and members of the subcommittee. I have a substitute for your consideration.
All right, it's been moved and properly seconded that we adopt a subcommittee substitute. As many as favor of that motion will say aye. Those opposed? All right, the substitute is properly before us. Delegate Sewell.
Thank you. The substitute, although it looks much longer than the original bill, simply just notes that in the original bill, it was a statement that said that real estate licensees were not required to have a written agreement with a prospective buyer prior to showing the property, and the substitute takes the opposite approach and makes it a affirmative statement that licensees working with buyers and tenants do not have to have a written agreement prior to showing property. So now before you have House Bill 1684 as substituted, which will require real estate licensees working with buyers and tenants to have a written agreement prior to showing property. Current law does not require this, so long as the licensee just opens the door, lets the person walk through the door and around inside the house, and does not answer any substantive questions about the property. Requiring a written agreement prior to showing property protects both the consumer and the licensee by establishing upfront what everyone's obligations are with respect to the work being done on behalf of the buyer. House Bill 1684 also defines the brokerage services that require a written brokerage agreement and specifically defines what it means to show the property. Finally, HB 1684 makes it clear that the real estate licensee representing a seller or landlord may show properties on behalf of their client to a prospective buyer or tenant without signing a representation agreement with the buyer or tenant. This bill was brought to me in coordination with the Virginia Realtors, and we do not know of any opposition, but I will let you hear that directly.
Are there any questions for Delegate Sewell from members of the subcommittee? So I think this is also, I think it's somewhat in reaction to a national lawsuit, right? There's a settlement that's required folks to enter into these brokerage agreements. And so this gives, I think, some definition and some clarity to Virginia realtors and real estate agents about how they can comply with that. I think in particular, I like your language on making it clear that if you're working on the behalf of the seller, showing a buyer on behalf of your seller client, you don't have to get a brokerage agreement with that person. And there's been, I know, a lot of questions I've gotten, I'm sure Doug Quinn might have some of them too, about that aspect. All right, so what I'm saying is I like your bill. Anyone here wishing to speak in favor of your bill? Please come forward.
Thank you, Mr. Chair. Erin Corman with the Realtors. Thank the delegate for bringing the bill. Happy to answer any questions about it and ask for you to support, please.
All right. Anyone else wishing to speak in favor of the bill? Anyone wishing to speak in opposition to the bill? All right, back to the patron. Any final words?
No, we're just grateful to stand before you.
All right, is there a motion?
Favorably upon this bill.
Move to report by Delegate Price, seconded by Delegate Thomas. The clerk will open the roll with substitute. She said it right, I didn't. The clerk will close the roll. Bill reports by a vote of 6 to 2. Thank you, Delegate Sewell.
Thank you.
All right, Delegate Gardner, you have 2 bills. Come forward.
Good afternoon, Mr. Chair. I'll take 1708 first, if that's
Okay.
all right with you. House Bill 1708 seeks to establish an access to housing task force. The task force is established to address housing challenges and increase access to affordable housing across the Commonwealth. It aims to provide both short-term and long-term strategies to improve housing availability, particularly focusing on low-income and minority communities. It's my understanding that you have a work group already in the Housing Commission, so I would certainly be amenable to sending this to the Housing Commission.
Okay. Well, let's hear from is there anybody here wishing to speak in favor of the bill? All right. Anyone in opposition? All right. And I think we've heard what the patrons' preferences, so we can maybe move things along. Okay.
Mr. Chair, I would move to lay this bill gently on the table and send a letter to the Housing Commission.
Second.
All right. It's been moved and properly seconded. We lay this bill gently on the table and refer it to the Housing Commission to work on this year and part of an existing work group and make sure that we get to these issues. The clerk will open the roll. Members will cast their votes. All right, the clerk will close the roll. Bill reports by a vote of, bills laid gently on the table by a vote of 8 to 0. Thank you, Delegate Gardner. But I almost said report because we're going to, I think, get what you want out of this process by having this bill sent to the Housing Commission. But
Thank you so much for that.
It's laid on the table. All right, Delegate Gardner, you have 1709.
I do. Now
We've heard this a little bit before, but I think it went by for the day. So let's hear about it. Let's hear about it.
All right. House Bill 1709, the Virginia Residential Landlord and Tenant Act. What this seeks to do is to make sure that many of the potential tenants who are renewing existing leases are required to utilize that lease and pay for internet and cable services that they may or may not want. This is typically done via a provision in a lease wherein sometimes the leasee is unaware of these additional changes in 30-page leases, which require them to pay money for services that they may not want or need. This bill was actually brought to me from constituents in my community who lived in an older housing development where a lot of them were required to renew their lease and pay these additional fees for internet services that they did not have in their previous lease. And some of them were actually forced to move because they could not afford to pay these fees. As you said before, I kind of brought this bill before, there's a lot of pieces to it that are really good pieces. We sought to clean up some of the language in the existing code, and what it does is prohibits agreements from forcing tenants to select specific service providers or pay for services they don't need. It expands the definition of service provider to include cable, broadband, satellite, and related TV and internet services. And it requires that the landlord must clearly disclose any fees related to these services and give tenants an opportunity to opt out. There are quite a few people here who would like to speak to this bill, so
I just want to make sure I understand that, and I'm trying to remember what happened last time. Was there a substitute, or is this
yes.
the bill?
I'm sorry.
Did we adopt that substitute last time? Or
I don't think so.
No. Is that what we want her to do, or do we want the original? Are we back to the original language? You want the new substitute?
We want the substitute, Mr. Chair.
All right. So there's a motion on the substitute. Seconded. Clerk, as many favor that motion will say aye. Aye. Those opposed? All right. So, Ashley, you have the substitute ready to go live online? Okay. All right. So while that's coming up for us to look at online, if those wishing to speak in favor of the bill that are here in the room will please come forward. Go ahead.
Good afternoon, Mr. Chair, members of the committee. I'm Michael Pruitt. I am here on behalf of Housing Opportunities Made Equal, which is Virginia's only organization dedicated to fighting housing discrimination in the state. And we are here to lodge our support in favor of this bill. I want to begin by just noting very briefly that this bill is fundamentally modernizing existing regulation. Such kind of in-building monopolies are already illegal when it comes to satellite, dish, cable services, and it was merely a circumstance of the context in which that bill was previously created that did not include these kind of broadband monopolies. When tenants are being forced, as they currently are, to pay for one provider's service, other providers aren't likely to see the opportunity to entering into the building and attempting to compete in that local, that hyper-local market. This creates a circumstance where bulk billing arrangements sacrifice consumer choice to preserve in-building monopolies at the expense of tenants. This fundamentally harms tenants and harms access to housing choice, which is why Home of Virginia is lodging its support. Thank you.
Thank you. All right, and as we move forward, you guys, some of y'all know the drill, but some of you are new to the committee. If we can keep it relatively brief, and if somebody in front of you has said what you want to say, there's no harm and no shame in saying, just associating yourself with their comments. And if you want to get the main stage, just get to the front faster, and then they'll have to repeat. They'll have to associate themselves with your comments later.
Okay. Thank you, Mr. Chairman, members of the subcommittee. Christy Mara with the Virginia Poverty Law Center. We also strongly support this legislation. What we are hearing about in particular are those tenants who are being forced to pay $60, $70, $80 a month for broadband service that they do not need because they are in a program that provides them that service for free. And so this is a very real problem that we're hearing about in different parts of the Commonwealth. We appreciate the delegate for bringing this bill and ask you to move it forward.
All right, come on forward.
Good afternoon, Mr. Chair and members of the committee. My name is Josue Castillo. I am a community organizer with New Virginia Majority, and we also strongly support this bill. I want to echo what was said previously. This is an issue that affects residents locally in Brookside, which is a community in Richmond. Tenants are receiving $65 internet fees, and this was not advertised to them when they initially toured the apartment, and many of them also receive reduced internet from their schools. So,
thank you.
Hello, Mr. Chair, members of the committee. Gustavo Espinosa with the Legal Aid Justice Center. We support this bill. I just want to add that when the Allies for Housing Action advocate for tenant protections, we often hear a lot of grief about the free market. This broadband monopoly is blatantly anti-free market, so I hope that the industry doesn't come out to oppose this. Thank you very much.
All right. All right, anyone here wishing to speak in opposition to the bill, please come forward.
Mr. Chair, members of the committee, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We do respectfully oppose this bill. All of these fees do already have to be disclosed, and its impact on existing and future bulk service agreements, which are essential for delivering affordable broadband for renters, is problematic. It's going to undermine and reduce competition and increase broadband costs for renters. And in the proposed changes, some of the red flags that we saw were there was ambiguity about which fees landlords may charge, the definition of a service provider, and whether bulk service costs can be included in rent. And so we do see a lot of issues in the language, so we will have to oppose. Thank you.
Thank you.
Mr. Chairman, members of the committee, I'm Ray Lemure, President of the Broadband Association of Virginia. I appreciate the delegates' challenge that we have before us. We, as a body, as the association, have been working for the past 7 years to get broadband deployed throughout the Commonwealth and adopted. We recognize the challenge that's before here. We would recommend that this go before the Housing Commission for additional study or to the Broadband Advisory Council. So I'd be glad to answer any questions.
I guess, let's stand by. Let's hear from everybody.
Mr. Chairman, members of the subcommittee, Jeff Palmer on behalf of the Virginia Broadband Industry Association. Our association is a lot of the rural broadband providers in areas where there's not competition for broadband. And so there's only one option, and our members want to build to these multi-dwelling units, but if there's no expectation that the residents there are going to sign up for these services, then you're requiring them to build out with just a hope and a prayer. And the advocates raise very, very good issues about some of the residents getting reduced broadband options. I think those are things we should work through, and I agree with Mr. Lemure that maybe this is something that we can find a venue to kind of work through some of these issues and bring something that's workable. So thank you.
All right. We also have some folks that are online. I think they're here to speak in favor. So Isabel McLean.
Good afternoon, Mr. Chair, members of the committee. I'll just be brief and say I support the bill and associate myself with the comments earlier with the Virginia housing rights. Thank you.
All right. And Emery Speed.
Hi, members of the delegate and the chair. It's Amori with the Virginia Majority Community Organizer, and I am in support of HB 1709 because it protects vulnerable tenants and ensures transparency in the Landlord-Tenant Act agreement. Specifically, it ensures tenants are fully informed of all costs associated with services provided by the landlord, helping to avoid hidden fees that could lead to financial hardship. And also protects the right to choose, meaning that every tenant has the right to choose which services, if any, that they would like to pay for and use without pressure of any landlord service provider. And for those reasons and the reasons said previously, I support the bill.
Thank you. All right, Mr. Lemire, if you don't mind resuming the stander, come back up. I do have a question because I know that sometimes it feels like we're just punting these things down the road with no real solution in sight as just a way to get this moved along. And I think that I know the patron is serious, as am I, in addressing some of this. But what I'm hearing from you guys is that the bill as written is unworkable. Could you elaborate a little bit on why we couldn't what would happen if we tried to pass the bill as written? I heard from Mr. Palmore and some others, it might just cause some people just to stop providing the service altogether. But what is it about this, the way it's drafted, that's making this something that needs more work? And then my two-part question, what could we accomplish, do you think, through a work group that are these things that can be overcome if we keep working on it?
Sure. I think some of these questions could be better answered by the Apartment Association, but I would say when a broadband provider does come to a multi-dwelling unit, they're able to expend those costs over the entire body. So reducing the costs for the entire. So in fact, what you may have a few constituents complaining today, you will have more constituents complaining tomorrow as a result of their costs going up. So you're also, kind of tipping the thing where someone may not want to use a gymnasium in their apartment. Well, they don't want to pay for that. So then you're creating a whole bunch of different problems going forward. I would also submit, I think the Broadband Advisory Council can help educate more constituents on the benefits of broadband, especially folks who may need to use telehealth rather than going down their hallway, tripping over something, getting an Uber, paying for an Uber to go to the doctor's, paying for an Uber to come back. That's probably already covered their cost. So that's just a brief example of some of the benefits here. But I think as we deploy broadband, more folks need to understand the benefits of broadband that's available to them. So I'm just a little disappointed to hear some of the advocates opposing this because I think their need has more education as well, but the benefits of what broadband is doing for this Commonwealth.
Gotcha. I hear what you're saying. I think your message is that the unintended consequences may be less access to anyone ever, and it's not just an issue of cost. Delegate Thomas.
Thank you, Mr. Chairman. I'm not sure which group could probably answer this question most accurately, but I guess it also sounds like I'm hearing there's an issue with, is there an issue with disclosure in leases? Is the issue not being disclosed, or for the patron, or it's an honest question.
Okay. And if somebody else can answer better. In talking with some of the advocates, it is a transparency problem because they have these leases that are like 30 pages long, and somewhere in there it said all fees, and sometimes those fees are not always. I'm not saying everybody does that, but there's a transparency issue. And then people who are renewing their lease, as someone said earlier, when they got into the lease, they were not aware that later down the road they were going to have to do that, and so they're being asked to accept these fees or move. And so they have no choice. So they don't have an option to opt out, and sometimes they're not aware of what the fees are because they're put in one big pile.
All right, I think Ms. Corman wanted to try and address the transparency issue, and then we'll go to Delegate Price.
Thank you, Mr. Chair. In response to that question, there was a law passed last year that requires all fees that are paid monthly, actually all fees, to be listed at the first part of the lease with a disclosure statement that says all fees are listed here. So any fees that are for broadband would be listed on the first page of the lease, actually at the very beginning.
And that's not changed, Ms. Corman, by the bill that we passed, my bill that passed it, that's sort of.
No, if anything, it's clarified even more that it would need to be listed there.
All right. All right, we're now a little bit of back and forth. Come on, and then we're gonna have to move on because we can't do rebuttal or server rebuttal over and over again. Go ahead.
Thank you, Chair. I do want to just briefly kind of hone in on the point that the delegate made, which is this principally arrives when you're in kind of a reletting situation. You have the opportunity to change material terms. The critical issue here is that these are not opt-outable. There are tenants, particularly very vulnerable tenants who qualify, say, for opportunities for free broadband through their school, who might have additional subsidies that they could use for another broadband service. They don't have the ability to use their free and subsidized services that they might have available to them by opting out. Instead, they are forced to pay during the reletting process what might be a surprise fee, or they might have gotten far along during their application fee, and this sneaks up on them when they see the final forms in front of them. Thank you, Chair.
Got it. All right, understand the concern. Delegate Thomas, does that answer your question? Or you have more?
Yes, mostly, Mr. Chair. Thank you.
All right, Delegate Coiner, do you want to be recognized? All right, all right. Somebody's going to have to get the last word at some point. Go ahead.
Last word. Just when there's a renewal, if there are material terms that are at any time, if there's material terms changing the lease but included at a renewal point, all parties have to agree. There's nothing being snuck into a contract.
Yeah, they have to agree or move, and I think that's what the other side's saying. And in other words, and I get it, but this is at the renewal point. So you brought in a new broadband provider, so you've been living someplace for 2, 3, 4 years. It's been fine. They make a contract with a new broadband provider that causes your rent to go up, right, by $60 a month. And I think that's, and again, regardless of what you think of that practice, I think that's the practice that this bill's trying to get at to some degree. Delegate Coiner.
Speaking to the bill.
Speaking to the bill.
I think on the one hand, when you look at affordable housing units and providers who do provide free or reduced cost to folks based on income, because there are a lot of programs that are out there, which is what I think the delegate was referring to earlier. They could have a service for free based on income or whatever it is, and perhaps looking at in specific affordable housing projects if it makes sense for those programs to play together. I think where we are right here is you look at aged multifamily communities, and when it comes time for them to renew loans and other things, a lot of folks will go through and over a period of years do upgrades to bring themselves up to modern standards, right? You look at some of our apartment communities that were built in the 80s, and in order to continue competing with new projects, they need to do upgrades. And I think by putting this in place, when you look at the difference in, at least in my practice area, with what we used to deal with in landlord and tenant complaints around the area of TV coverage, right? It was always, well, whose responsibility is it when something's not connected properly? Because the landlord would put part of it in, and then every tenant would have their own providers, and it took a lot longer to get TV back up and running when you were going back and forth between who was responsible for what. I think the benefit of the model that's been put in place is the landlord's responsible. If there's a problem, they go fix it, and it has brought the cost down for everyone. So for that, I understand the issue. I think there might be another way in the affordable housing area to have more conversations about the existing programs that help supplement tenants, and then there's a way to match those up if a whole project is defined in that area for housing that meets those income requirements, Mr. Chair.
All right. So, I like your bill. I don't know if it's quite ready for prime time. I wish that we could get all these issues worked out, but if you're open to one of the suggestions, whether the Housing Commission or the or the Broadband Advisory Commission or neither, but assuming if for a second that it doesn't get reported, would you have a preference as to where you'd like to see this issue examined further?
If it doesn't get reported, I would rather go to the housing.
All right.
I don't want to put the fox in the
I
house.
understand. Okay, fair enough. All right. All right. Is there a motion?
Mr. Chairman,
Delegate Carr.
I move we lay this gently on this table and send it to, oh, sorry. I move we lay this on the table and gently and send it to the Housing Commission.
All right. It's been moved and seconded. The clerk will open the roll.
I'm pushing my attendance.
All right. The clerk will close the roll. Thank you, Delegate Gardner, for your work on this issue. And again, I do hope that we can get something done on this quickly because I think it's a problem that needs to be addressed.
Thank you.
All right. Delegate Cousins, is she still here? All right. She's getting pinged by another committee to be there too, but I appreciate you staying with us so we can keep moving. Delegate Cousins.
Appreciate it. Thanks, Mr. Chair, members of the subcommittee. You have before you HB 2229, which came before this committee last session as well. All too often, families are living in homes with serious maintenance issues that impact their health and safety, which go ignored and unfixed by their landlords. The Virginia Residential Landlord-Tenant Act requires that landlords maintain safe and habitable rental properties. However, under current statute, tenants cannot file a suit if they are behind on their rent, regardless of how much they owe. In practice, some clerks do not allow tenants to file actions after the 5th of the month to avoid running afoul of this requirement. This essentially denies tenants access to the court system, and it also forces tenants to wait weeks living in unhealthy and unsafe housing before they can address the issue in court. HB 2229 simply removes the requirement that tenants be current on rent to file a tenant's assertion. Once they file the tenant's assertion, they will still be required to pay rent into escrow. This does not apply to unlawful detainer or eviction cases. It only applies when a tenant is making an affirmative action against the landlord in court for failing to meet safe housing standards. And again, this bill does not change the existing requirements that tenants pay rent into escrow upon filing an assertion. This bill strengthens tenants' ability to access the judicial system, and I hope the committee will support it.
All right. Any questions from members of the subcommittee? Okay, we heard this bill in civil sub last year, I think. Delegate Cousins, is that right? And
I think it was here because I remember Mr. Chair, Delegate Pointer having a question.
it might have gone both places, actually. I think it might have been referred to both committees. All right. Any questions from members of the subcommittee at this moment? If not, if there anyone in the audience wishing to speak in favor of the bill, please come forward.
Is there a line amendment? Oh, I'm sorry. I think I need to move a line amendment. Oh, yes, I do have line amendments. I'm sorry about that.
It's moved in second. We adopt line amendments. As many as favor of that motion will say aye.
Aye.
Those opposed, line amendments are before us. All right. Council, you want to tell us real quick, are they technical or tell us what the line amendments do real quickly?
Sure. Yes, Mr. Chairman. On line 34, after due, strike, subsequent to the initial court date called for under the rental agreement. And on line 35, after under, strike such and insert the.
All right. All right. Those wishing to speak in favor, please come forward.
Good afternoon, members of the committee. Mr. Chair, my name is Janae Craddock with the Virginia Poverty Law Center, and we are in support of this bill. As indicated, you all did see this last year, and I just want to clarify that this is an access to justice issue. The VRLTA breaks down into different categories. You have tenant obligations, landlord obligations, tenant remedies, landlord remedies. Those obligations that the tenant have aren't contingent upon the other and vice versa. But oftentimes, due to improper interpretation and enforcement of this, of the current statute as written currently, tenants are denied the right to file and maintain an action this, just because they are deemed to be delinquent. And so what we want to clarify is that this is just making sure that tenants are able to actually be able to file those cases when necessary, when the landlord is non-compliant to request. And this is not just requests for peeling paint. These are actually things that they are required to provide under the law. They are required to maintain fit and habitable premises. And so we're asking you all to support, to vote in favor of this bill. And another thing I just want to leave with you all is that unsafe housing conditions leads to unstable housing. And as you all know, we still are in a housing crisis. And this is to ensure that landlords comply with their obligations, but also, to be clear, tenants are still required to comply with their obligations to pay under the law.
All right, thank you. All right, again, same admonition. If you've got new arguments, we'd love to hear them. If they're redundant, just associate yourself. Thank you. Go ahead.
Thank you, Chair. Mike Pruitt on behalf of Home. I would like to echo my colleagues' support in favor of this bill and reassert those arguments. I would also briefly note a dual capacity. I am also here as a member of the Albemarle County Board of Supervisors. My peers and I on the Board of Supervisors receive frequent complaints from tenants about issues of material noncompliance from their landlords and severe habitability concerns. And we have very limited ability to deal with that. And this leaves us very little opportunity to help our tenants. That is why our board collectively has decided to support measures such as this one, as well as the bill by Delegate Price, that help expand access to justice in issues of material noncompliance so that we can actually deal with these issues effectively. Thank you.
Thank you.
Good afternoon, Mr. Chairman, members of the committee. My name is Victoria Horak. I'm with the Legal Aid Justice Center, and I want to thank the patron for bringing the bill. I represent low-income tenants in Central Virginia, and this is probably one of the #1 issues they bring to us is the lack of habitable housing. We represent tenants who are living in horrific conditions. I had a trial on Friday about a tenant who had fecal matter come up through the sink and the washing machine in her apartment. I've had to counsel tenants whose babies can't crawl on the floor because there are rats. I've had to tell them that they actually cannot file a case against their landlord for that because they're behind on their rent. And I want to echo what Ms. Craddock said. This is an access to justice issue. Both the tenant and the landlord sign a lease. It obligates the tenant to pay rent, but it also obligates the landlord to keep up fit and habitable housing. If the landlord breaches the lease and there are rats in the apartment, and then the tenant hasn't paid $5, arguably both parties have arguably breached the lease, the landlord can go to court, the tenant cannot. So this is an issue of equity between the parties. We support the bill.
Thank you. Real quick, we're going to interrupt for just 1 second. Go ahead.
Mr. Chair, if I could ask a question of the patron. So I voted for this last year. Is anything changed dramatically or at all? Is it the same bill as last year?
It's the same bill as last year. If anything, we added additional language. I will admit I've been working with the governor's administration on this to hopefully not, so that it will hopefully pass and not be vetoed. But we just added language, subsection I at the end of the bill, that just indicates and reiterates that nothing in this section will affect the unlawful detainer provisions. Other than that, it's the same.
Thank you.
Yeah.
I was trying to compare them. You saved me time.
Yeah.
Thank you.
All right. And so just folks, we were speaking for counting heads now. That looks like that's a promising sign, so but keep coming forward.
Good afternoon, Mr. Chair and members of the committee. My name is Josue Castillo. I'm an organizer with New Virginia Majority. I want to echo all of what was said, but I also want to add that I have hands-on experience with tenants who have lost their groceries for their entire week because their landlord refused to fix their refrigerator, and they have to spend extra money on these emergency situations caused by their living conditions, and that ends up making them behind on rent. I've met families who've lost their children's medicine, who've had to choose between buying essentials for their child to survive or paying rent. And what I'm seeing in Richmond is that these housing conditions are causing people to spend more on basic necessities like food and medicine, and we're not giving tenants the same power to file a tenant's assertion, because after day 5, that letter gets sent to them, and I wish that my tenants would have that same power.
Thank you.
Mr. Chairman, members of the committee, my name is Brandy Singleton. I'm with the Office of the Executive Secretary. We're the administrative offices for the state court system. Our committee of district court judges that review legislation for us that touches upon the kind of cases they hear with regularity wanted us to support this bill. They saw it as affording greater judicial discretion to get these cases before the courts and resolved. Thank you.
Right. For those of you that follow, it takes a lot for OES to get up and actually support a bill. Go ahead.
Good afternoon, Mr. Chair, members of the committee. Sheila Hurley-Hennessy with the Virginia Interfaith Center for Public Policy, and we support the bill and associate our comments with those who came before. Thank you.
Thank you. That is excellent testimony for those of you that are following along. That's the way I like it.
Peace and blessings, everybody. My name is Jafari Jones, president of BLM 757, also known as Black Lives Matter 757. Speaking in support of this bill, because directly out of Newport News, where Delegate Price's district is, there was a housing authority. There was a tower about 2 years ago where over 100 people were displaced due to a slumlord situation, and these individuals were forced in less than 30 days to have to move into hotels and things that they could not afford, and we are still trying to fix this crisis. So we would definitely appreciate if you would vote yay on this bill. Thank you so much.
Thank you. And online, I know we have one in favor, so just to keep all the in favors together, Emery Speed, if you're available.
Hi, folks. I'm back. I'm Maury Speed, community organizer with New Virginia Majority. As a person that has been working in these communities and working with the people that this bill aims to protect, in the comments previously said before, I support the bill.
Thank you so much. All right. Anyone here wishing to speak in opposition to the bill, please step forward. All right. Seeing it's been moved and seconded, the bill report is amended. The clerk will open the roll. The clerk will close the roll. Bill reports 8-0. Thank you, Delegate Cousins. Office of Labor and Commerce for you. All right, Delegate Carlson and Delegate Anthony, you guys both have bills on algorithmic pricing. Did you guys want to present it together? Do you want to do one at a time? What's that? I know they're not the same. They're on the same issue. Well, why don't we take Delegate Anthony first? Or no, Delegate Carlson wants to go first. Delegate Carlson first.
Thank you, Chairman Simon and members of the committee. I do have a substitute that I would like to move.
All right, it's moved and seconded that we report the substitute. As many as favor of that motion, or we adopt the substitute. As many as favor of that motion will say aye. Aye. Those opposed? All right, the substitute's before us. Delegate Carlson, tell us about your substitute.
Thank you, Chairman Simon, and I'm happy to talk to the nature of the substitute, but I think a more productive conversation would just be about the bill in general. The substitute, some minor clarifications that helped stakeholders.
That's what I meant. Yeah, go ahead. Go ahead. Speak to the bill now as substitute.
Okay, so this bill has a complicated name and ended up being a really complicated bill. It is about algorithmic price setting, but it's actually trying to target a simple behavior, replacing competition in rental pricing with coordination. I have some quotes here. You all might have heard of it. There's lots of pending litigation in other states where they have had a cause of action to go after these corporations or these software services. In many of that litigation, documents have been collected, and I want to read you some of the quotes. So one of these service providers said that our tool ensures that landlords are driving every possible opportunity to increase price, even in the most downward trending or unexpected conditions. How they do this is that whoever subscribes to the service shares with them competitive data, non-competitive data, public data. They share it all with them, and then this service acts as an intermediary to allow them to collude with each other and set the price as high as it could be in the market. Some other quotes from one of these service providers, Vice President of Revenue Management, said, "There is greater good in everybody succeeding versus essentially trying to compete against one another." As he put it, if enough landlords used RealPage's software, they would likely move in unison versus against each other, and a rising tide raises all ships. In this case, the rising tide is our housing prices. The executives of the companies are very blunt. They want landlords to avoid racing against each other. What is not as clear is how we can go after that type of collusion. It is generally covered in the Sherman Antitrust Act that was written in 1890. It did not anticipate the kind of evidence that we would have with collusion that is happening nowadays. And for that reason, bringing a collusion charge requires a bunch of factors that aren't really being replicated here, because generally it anticipates that you would be having a direct conversation with someone, but by having the software, you avoid meeting that evidentiary burden. So it's really important for states to set out how and why this is illegal, so that our Attorney General knows that he can go after, he or she or wherever we end up, can go after this type of behavior, because it is hurting us all. The outcome of software services like this are increased rental prices. One multifamily housing executive who was referenced in litigation in another state put it best when he said, "We let the company push as hard as it would go, and we saw increases as high as 20%. Left to our own devices, I can assure you we would have never pushed rents that hard." It also decreases concessions to renters. I'm almost done. Thank you, Chair Simon.
Saw that look, huh?
And it results in dynamic pricing, which I'm in a house. Many of you are probably in a house. We haven't been in the rental market in a while, but I've talked to many LAs. When you go to rent a property right now, there is dynamic pricing, as if you are buying airline tickets. So if you look in the morning, you'll get a different price than when you look in the afternoon, because they are able to use this software to do that level of collusion. It also results in a market that is not actually responsive to free market conditions. Small, honest businesses suffer, and consumers. There's a lot of hurdles left, though. It's legislatively complicated, and I have people to speak in support, and I can answer questions about where we arrived.
Well, so I guess the question is, you've identified the problem very eloquently, I might add, but how does your bill fix it?
So I'm happy to tell you the various levels of debate we had. Right now, the Attorney General is specifically forbidden from operating in basically our housing issues, our VRLTA. Did I get that right? I said it fast. So they're prohibited from diving into that. If you go to the Attorney General's website right now to lodge a complaint, and you say landlord issue or rental issue, it brings you to a page that says this is not our area. There's nothing to do. So although I tried to originally put it in Consumer Protection Act, we ultimately are trying to just get a section under the VRTLA so that it creates a path by which the Attorney General can at least accept complaints and gather data so that he can bring this suit.
All right. And then I guess my other question is, there's a Senate cognate to your bill?
There is a Senate cognate to my bill.
Okay. And again, obviously, we are not bound. We're our own independent body. We can do whatever we want. But for the sake, just for the sake of everybody's knowledge, that bill was laid on the table and referred to the Joint Committee on Science and Technology to look at this issue further. Is that right?
That is correct, Chair Simon. And if that was the will of the body, I'd be happy with that, although I would also be happy to go and try to fight for it over there.
Understood. All
and
right.
work on it.
With that, anyone wishing to speak in favor of the bill, please come forward. Again, I think we've got a really good idea of what the problem is. I'd love to hear from you all is what you think some solutions are, and if this bill is in fact that solution. Go ahead.
Thank you, Chair. Mike Pruitt on behalf of Home. The structure of current price fixers creates layers of ambiguity between competitors. You no longer have landlords talking to landlords. Instead, you have a third-party algorithm that spits out a price rather than that direct competitor themselves. The price is presented as a recommendation, even though industry associations will often require the use of a recommended price, making it effectively a requirement. And the competitor data is semi-anonymized, so it's not directly seen by the peers. This layers of ambiguity can make litigation challenging, and it can make it a question of law that has to be hashed out slowly. This bill seeks to clarify that something that is already illegal, something that we know from the lawsuits brought by attorneys general across this country, is already illegal. It clarifies that it is what it is. It is price fixing, it is harm to tenants, and it is something that turns a system into something that is fundamentally unfair and, frankly, quite literally, fundamentally unhuman. Because this bill clarifies that these creative efforts by price fixers to kind of innovate out of existing regulations, it clarifies that this must fail, that this is illegal under current law, and it creates a clear remedial scheme for how to handle it. For these reasons, Home supports the bill. Thank you.
Thank you.
Good afternoon, Rena Hicks with Freedom, Virginia. We do have a housing crisis, and that's going to involve a really intentional policy choice that encompasses all the above: zoning reforms, increasing supply, ensuring what's currently on the market is fair. Algorithmic pricing softwares do not allow for a fair and competitive free market, and the question is whether the General Assembly will support landlords colluding to increase rental prices or not. I hope you support this bill. Thank you.
Thank you. Next.
Christy Mara with the Virginia Poverty Law Center, and for all the reasons prior witnesses stated, we support the bill.
Thank you again for that excellent testimony. I will continue to give you positive reinforcement when you're short.
Josue Castillo, New Virginia Majority strongly supports, and so does the Allies for Housing Action.
Thank you.
Sheila Hurley Hennessy, the Virginia Interfaith Center for Public Policy, also supports the bill. Thank you.
Thank you very much.
Victoria Horak, Legal Aid Justice Center, and we support the bill.
Thank you.
Jason Melendez with Delegate Carlson's office, supportive of the bill, and I'm also a member of the Human Rights Commission in the city of Charlottesville, so we receive complaints as well.
All right.
That's what I was trying to figure out.
Sarah Graham Taylor on behalf of the City of Alexandria. We support the bill. Thank you.
Okay. All right. Anybody wishing to speak in opposition to the bill, please come forward. And again, same rules apply. It's be brief and don't repeat each other, please. Thank you.
Thank you, Mr. Chair. Erin Corman with the Realtors. I'd like to thank the delegate. The delegate's office has worked back and forth with us on this language, but we just were not able to get there. We completely understand the intent of this bill. We know about the federal lawsuit, all the states that are suing as well. I just want to clarify that this is one specific software company who had an algorithmic device that was being used improperly. They were, if you believe the papers, blatantly violating antitrust, which we already have the ability to fight in this state. The way that this law is written is so broad, it includes all algorithmic devices. It's very unclear as to what non-public data is, when is it being used improperly. The federal lawsuit has not figured that out yet. It has not gone through and figured out which components of public versus non-public information make the whole system illegal. And we just need to be really careful, because I think if you look at some of the programs we use on a daily basis, including the multiple listing service, these are all algorithmic devices. They all use public, widely available information that any consumer can access on the internet. And so our concern is that this bill is a little premature, that it's incredibly complex. Even in all the conversations that we've had, there's been a lot of confusion, and we would just like some more time to work on this issue before we start prohibiting things.
All right, thank you.
Thank you.
Mr. Chair, members of the committee, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We echo the comments of the previous speaker, especially echoing that there is an ongoing lawsuit here. The bill is just written very, very broadly. And as you probably know, we use AI tools very frequently in just setting and recommending rent. It's widely used across industries to analyze trends and ensure fair pricing. So we don't want to do anything too prematurely here. Instead of an outright ban, we urge the committee to conduct a thorough study, especially since this is such a complex issue, before going forward. Thank you.
Thank you.
Mr. Chair, members of the subcommittee, Zach Lemaster with Gentry Law Consulting here on behalf of the Northern Virginia Apartment Association, and we would associate our comments with the previous speakers.
Thank you. One more.
Mr. Chairman, members of the committee, Tracy Boehner with McGuire-Woods Consulting representing RealPage. We are the subject of the DOJ study. There have been some facts stated that are at the heart of that litigation that are going to be decided. For example, our subscribers are not required to take our rent range proposal. They can do with that as they will. In fact, only about 35% of them do take it on average. Thank you.
Thank you. All right, we've got a couple of people queued up to ask some questions here from the subcommittee. Do you want to have,
And if
you want to get the last word, or you want to respond now before you forget? Go ahead, Doug.
If I could respond, because it's fresh in my head and it's been a long week and it's going to be gone soon.
Fair enough.
Thank you, Chair
Understood.
Simon. One commenter mentioned that ongoing litigation. I just want to clarify there is no ongoing litigation in Virginia. Another commenter, person opposed, said that their system uses publicly, I think roll back the tape, publicly widely available data. That is not what this targets. It targets non-public competitive data, so that would not be covered. There was some disagreement among the people who opposed about whether or not RealPages is doing this or not, or whatever service is. And then someone said there's only one service provider that does this, and there are 3 in the nation. So just clarification.
Okay. Delegate Coiner.
Thank you, Mr. Chair. One of the detriments of a short session, because there's a lot of issues that I'm like, but given the point we are in session, I really think we ought to be trying to figure this out. I'm just not sure. I have a bunch of questions, and I'm not sure at the dais, but I'm going to ask some of them and see where we can go. But, anytime I see so much new stuff added into code, I often would just like to know, is this the exact same language used in other states? And if so, what states and when did they put them in place, right? Because sometimes someone goes first and then we learn lessons from them. So that's my first. If you want to respond to that, and that way I'm not hammering you with questions.
Sure, Simon. I thank the delegate for that because, again, it's been a long day. I do not. So it was proposed, I know, in at least 2 states, Colorado and New Jersey being those 2 states. I don't know the outcome there. It has been, this language was originally modeled after local ordinances. Some localities have adopted policies trying to prohibit use of these services. That's what it was based on. I do not think there is a current state that has a law, but with the caveat that this law is to make it so our AG can do the lawsuits that many other states are doing right now.
Okay.
Delegate Coiner.
Thank you, Mr. Chair. My second question, kind of in line with, and again, I agree with you, long week and long day. So if this is already not supposed to be happening, do you think, rather than trying to figure out this whole code section that's a little complex for me right now at this point, that there's something else that the AG, we could already be directing that they do, or they could do without this, or do they have to have this, do you think, to do it?
Chair Simon, I would answer the delegate that's an interesting question, and I think some directive to the AG's office would certainly be helpful. I will point that one of the people in opposition had mentioned how one of the workarounds that they have and why they don't think this applies under the existing law around antitrust and collusion is because they can point to a percentage of people that aren't doing the colluding, and the way the law is written right now is it has to be basically like a cartel where you have no option out, and so they're using that little loophole to make it so that they can't be taken under an existing law. So I've at this point almost lost my train of thought, but I think I'm doing a pretty good job. So so that's what this bill, a letter to the Attorney General directing them that they can go after this, but I also think legislation is important because there are those loopholes that they are clearly aware of.
Thank you. All right. Anything else, Delegate Coiner?
Mr. Chair, I have so many questions, but again, I'm going to stop at this point, but I get it, is
Delegate
what I'll
Thomas.
say.
Thank you, Mr. Chair. I guess on the same line as Delegate Coiner with questions, I love what the bill is trying to do, Mr. Chair. And I like insider information, bad, don't like it. It kills markets, it kills innovation, not a fan of insider information. But I guess on one of my several questions, and I'll just ask one, it has to do with the definition of non-public competitor data. And the definition, I'm just concerned where I think it should be okay if a landlord who owns one property puts into ChatGPT, hey, for this rental market, what should I do? I don't really know what to charge right now. I just do this one little thing and it, boop, 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 it bops something out, that's fine. Is this bill broad enough and that definition broad enough that you actually couldn't do that, Mr. Chair? Or is this just targeting, I just don't know enough about LLMs and how they crawl information, what's available and what's widely available, even though they're both technically public on a public domain. I'm just concerned that the bill would then wrap up somebody who's innocently using ChatGPT. While I'm all about you going after these, other groups that are, those quotes are terrible, and we should definitely stop that. But I'm worried that it's very over inclusive right now of various people, and that's my concern, Mr. Chair.
Delegate Carlson.
Chair Simon, I would answer the patron that there's probably someone else who wants to give a better answer, but my quick answer would be that we did coordinate with a lot of stakeholders to try to identify some of those other sources of data so that we had a better sense of what data is out there. One of the things we arrived at is that you don't typically get daily rental reports. That's not something that's typically publicly published or available. It's usually quarterly or monthly, and so we were trying to work with the definition. I'm sure Mr. Pruitt will have an answer as well.
Thank you, Chair Mike Pruitt, on behalf of Housing Opportunities Made Equal of Virginia. So the answer to the question, Delegate Thomas, would be that there is publicly available data on rental prices, and that would be what an LLM would be drawing from. There wouldn't be any kind of non-public input that is being fed into that LLM that would allow it to make that determination. That would be in violation of this bill as written. What this is instead targeting is there's a distinction between, frankly, advertised rents and actual rents. As we talked about earlier with dynamic pricing, you apply to an apartment building, maybe you see a listing on the side of a building, it advertises $1,000 a month, and then by the time you actually are signing the lease, the terms on the paper are different than that. Maybe it's $1,200 a month. That is what is captured. That is the kind of non-public data that is at issue in this. As well as we should potentially note, non-public data can include a lot of other material lease terms that could be captured up in this kind of dragnet of information shared amongst competitors and coordinated.
All right. So I think we have an idea where this bill is going to go. I think we've had given it a full and fair hearing, and I'm ready for a motion.
Move to gently lay on the table and refer to Jaycox.
That's where the Senate one went, so it makes sense to send it to the same place. All right, it's been moved. Is there a second?
Second.
All right, clerk will open the roll. Clerk will close the roll. Bill is laid on the table by a vote of 6-2.
Thank you, members of the committee.
All right, Delegate Anthony, with that context, I know your bill is different, but with that context, that conversation, why don't we go ahead and take you next, since your bill is on a very similar topic.
All right, Mr. Chair, members of the subcommittee. Here we have HB 2047. It is a housing-focused investigative tool bill designed to protect renters from unfair rent-setting prices. It does set up an ombudsman within the infrastructure. But while some opponents say that the existing consumer data protection laws already cover this issue, the reality is that the Virginia Consumer Data Protections Act does not regulate housing affordability, fair competition, or rent pricing. And so the bill is not about personal data privacy. It's about ensuring that rent prices in Virginia are set fairly and competitively. And so here, when landlords use algorithmic pricing devices that rely on non-public competitor data, it artificially inflates rents. And so this bill ensures that the landlords set rental prices based upon open, competitive market forces, not secretive back-end data exchanges that the tenants will never see. So here are three things the bill does: prevents landlords from using non-public competitor data as defined in the bill, and set rent prices, ensuring a fair and open market, requires transparency. Tenants must be informed of their rent, that their rent is set by an algorithm. It does create a housing-focused enforcement mechanism through the algorithmic rent pricing ombudsman, who will investigate and monitor pricing practices. And so some in this room may argue that there is a federal investigation already underway. But why can't Virginia set up an entire infrastructure? I think renters can't wait while uncertain legal processes unfolds. And so Virginia has the responsibility to act now, as our rental market operates fairly. Federal action, even if it's successful, might result in a broad penalties, not the Virginia-specific protections renters need. So HB 2047 directly addresses how algorithmic pricing tools are affecting our housing market here and now. And so we know that technology is ever evolving than our housing laws. And so we must act now to ensure that emerging tech serves the people and not just corporate profits. And so here we are. This bill is a first critical step in building that infrastructure with an ombudsman, and we'll continue to work on this. And so again, that algorithmic rent pricing ombudsman will educate tenants and landlords on their rights and obligations. They will monitor developments in housing-focused algorithmic practices. They will collaborate with other authorities, such as the Office of Attorney General, for broader enforcement, even when things crosses over into the Virginia Consumer Data Protections Act. And so it does provide clear investigative powers for the ombudsman to accept and investigate tenant complaints, et cetera, et cetera. And so I hope it is the will of the subcommittee to pass this bill.
All right, I thank you. I appreciate the sort of the work group and the study approach. We'll see where we get. Delegate Coiner, do you have some questions on this one? All right. Anybody wishing to speak in favor of this bill? Again, if it's the same issues and the same things, if you can line up and say your names if you want, or raise your hands. Come on forward.
Mike Pruitt with Home of Virginia. For the reasons thoroughly laid out previously, we support the bill.
All right, thank you.
Christy Mara, Virginia Poverty Law Center, and I just echo the remarks of the previous speaker. We support the bill.
All right, thank you.
Victoria Horak, Legal Aid Justice Center. We support the bill.
Thank you.
Gayleen Knoyton, Virginia NAACP. We strongly support this bill.
Thank you.
Sheila with the Virginia Interfaith Center for Public Policy. We also support the bill.
All right.
Thank you.
And those opposed would be the same as were opposed last time? You guys feel like you need to come up, or you can wait from there? All right. Thank you, guys. All right. Questions from Delegate Coiner?
Thank you, Mr. Chair. And I should know this answer, and I think I'm just tired, Mr. Chairman. So when we have other housing complaints, like, for example, if someone is unwilling to screening for vouchers, right? They're not supposed to. So do those investigations go directly to the AG's office, or do they also go through DHCD? It goes
I think
directly
we
to the
established, Mr. Chair, I think I will answer the delegate that I think we established that protocol from the previous bill. However, this ombudsman will hear the complaints for algorithmic pricing addressed that's not covered by the Virginia Consumer Data Protections Act.
Mr. Chair.
Delegate Coiner.
So that, so I was actually asking about other programs of things that we don't want people. I think I see folks and maybe a phone a friend who's helping. So today, if you complain that a landlord is screening you based on your income, right, which they're not supposed to do, who investigates that complaint? That's my question.
Thank you. Christy Mara with the Virginia Poverty Law Center. Mr. Chairman, Delegate Coiner, I think if you're referring to, for example, a landlord who's improperly asking for a certain level of income from a Section 8 voucher holder, that is a violation of our fair housing law, and you could go to the Fair Housing Office of DPOR to investigate that complaint. You could also simultaneously file an action in court. But there are only limited, Mr. Chairman, only limited types of complaints against landlords that have that type of administrative avenue. So most of your, if not all of your violations, alleged violations of the Virginia Residential Landlord Tenant Act only give you a private cause of action in the General District or Circuit Court.
Follow up, Mr. Chair.
Delegate Coiner.
So I guess looking at these two, this creates two steps. It takes you through, develops a new section under DHCD for a new section for investigating, and then it sends you through the AG process if it's deemed.
And Mr. Chairman, Delegate Coiner, that would be analogous to the Fair Housing Office today. If you go to the Fair Housing Office and they deem that it is a potential violation, then they would give you, if my friends from home may come and tell me I'm using the wrong language, but essentially a right to sue letter, and the Attorney General can take that action.
And then a question outside of this area, Mr. Chair.
All right, Delegate Coiner.
So then I guess my next question, Mr. Chair, would be looking at the beginning says what you shall not do, but then the section at the bottom where we're adding in the 55.1-1219.1, we're saying if you do use these things, you should disclose, you have to disclose them, and if you don't, your remedy is to terminate. But wouldn't your remedy be taking you back up? Wouldn't you be violating the previous section?
I'm not sure.
So isn't it not, I guess,
I'm confused.
maybe I'm reading that incorrectly.
I'm not sure.
All right. We're not going to try and answer that. Sorry. We're going to move on. Here's what we're going to do. So, Delegate Anthony, a couple things. One is your bill, because it creates this new office of ombudsman, has a pretty significant fiscal impact. We're actually past the deadline for us to refer things up to appropriation. So if we were to report and refer, it probably wouldn't get heard up there. And I don't think that would be the better outcome. I think the better outcome would be is if we could lay this bill on the table, send it to JCOTS with Delegate Carlson's bill, and have the study piece of what you're trying to do in the work group piece. Hopefully, given that we've referred them this issue, we'll get a good group together to start looking at this issue and digging into some of the questions that we've had. So I want to keep these two bills in the same posture. And then hopefully we get a lot of what you wanted with your bill, which is the issue studied, some recommendations, and some actionable legislative suggestions that we can take into account and introduce as bills next year. So with that, I entertain a motion.
Chairman?
Delegate Carr.
Move that we lay this bill gently on the table and have a letter sent to JCOT along with the other bill that was being considered previously.
All right. It's been moved. Is there a second? Second. All right, it's moved and properly seconded. The clerk will open the roll. The clerk will close the roll. Bill is laid gently on the table. Thank you,
Mr. Chair.
Delegate Anthony. And again, thank you both for raising this issue. As Delegate Quinn was saying earlier, it's a short session. I know that had we more time and more meetings, we might have gotten further along. This is a lot to tackle in 40-some days, all right? And particularly when crossover is only like 20-some. All right, let's change things up a little bit. Let's get Delegate Clark up here. Let's see if we have some fireworks. See if we get some sparks to fly. Delegate Clark, you don't look like Delegate Garrett, but I understand that you are presenting on his behalf today.
Oh, really?
Yes. I'm helping out Delegate Garrett today. I know we do not favor.
What is it they say about politics?
Awesome. Today I have HB 2067. There is amendments to be moved.
Second.
It's been moved and seconded that we adopt the amendments. As many as favor that motion will say aye. Aye. Those opposed? All right, the amendments are before us. Delegate Clark.
Awesome. Thank you, Mr. Chair. HB 2067 would give localities the option to permit or not permit the sale of consumer fireworks after the individual or business entity obtains a permit that follows the minimum requirements set forth in the statewide fire prevention codes. It also creates a 10% tax that will go directly to localities' public safety's budget and an additional 3% tax that will go directly to the locality's fire marshal. The same logic that we use around cannabis is applied here. We know that these products are already here in Virginia, and we might as well go ahead and regulate this market so that we can get it right away. If we pass this bill, we can ensure that safety standards, age restrictions, and provide revenue to offset any negative externalities that are already afflicting our communities. I do urge the committee to support this bill.
All right. Anyone here wishing, any questions from members of the subcommittee? All right. Seeing none, anybody here wishing to speak in favor of the bill, please come forward.
Mr. Chair, members of the subcommittee, Dylan Bishop of Wilcox Savage Consulting on behalf of Phantom Fireworks. I couldn't put it any more succinctly, so I'll just leave you with our support for the bill and appreciate your time.
All right. Thank you. Again, anyone else wishing to speak in favor of the bill, come forward.
Mr. Chairman, subcommittee, Leonard Johnson, Franklin City Council, and we support this bill.
Thank you. All right. Anyone, and who's online for this? Anyone wishing to speak in opposition to the bill, please come forward.
Mr. Chairman, Devin Cabot on behalf of the Virginia Fire Chiefs Association, and they have a long-standing policy that they oppose the expansion of fireworks in the Commonwealth. Thank you.
Thank you.
Mr. Chairman, members of the committee, Stephen Seitz, representing the Virginia Fire Prevention Association. We oppose this bill, expansion of any kind of consumer fireworks that go up in the air, explode, due to hazards to personnel and property. Thank you.
Thank you.
Mr. Chairman, Ed Rhodes, representing the Virginia Association of Rescue Squads, Governmental EMS Administrators, Virginia chapter of the Association of Arson Investigators and the EMS Regional Councils, and we strongly oppose this bill.
Thank you.
Mr. Chairman, members of the committee, I am Bonnie Atwood. I represent the Fire Prevention Association. I know you've heard from them, and I agree with them, of course, but I have just a couple of brief things to add from other constituencies. One is that I am a mother of a child with autism and a former president of the Autism Society, and I know how fireworks affect this population severely. I also was given one sentence to read from the CEO of the SPCA. It says the Richmond SPCA is also opposed to this bill due to the detrimental effects of fireworks on both companion animals and wildlife. And finally, it's common knowledge that people with PTSD have difficulty with fireworks, and there are many people in that category. Thank you very much.
Thank you.
Mr. Chair, members of the subcommittee, David Skiles with the Vector Corporation representing TNT Fireworks. Feels a little bit like Groundhog Day since this is the 13th year that this bill has been before the General Assembly. But we obviously have some concerns with the bill as introduced. I have seen versions of the substitute. Some of those versions make it marginally better. But our concerns are with the way that the bill is structured, it would have a tantamount impact or effect of banning fireworks sales in the Commonwealth writ large. And so for those reasons, we are opposed to the bill. Appreciate the patron working on this matter for many, many years, and understand Delegate Clark is stand-in for him today as a co-patron, but we are opposed to the legislation.
All right. All right, anyone, any questions from members of the subcommittee? If not, the committee operates by motion.
Mr. Chairman,
Delegate Carr.
I have a motion. I move that we lay HB 2067 on the table.
Is there a second? It's moved and seconded. It's not debatable. The clerk will open the roll. Members will cast their votes. The clerk will close the roll. Bill is laid on the table by a vote of 6 to 2. Thank you, Delegate Clark.
Thank you, Mr. Chair.
We will tell Delegate Garrett what a great job you did on his behalf. All right, Delegate Hernandez, you have just an amendment, right? And so we've heard this bill, just to be clear, we heard this bill last week. It didn't get a motion, so there's nothing, no action was taken, but we do have an amendment. We got a motion to get a second. No action was taken. All right, so. Do you have an amendment, though?
Yes, Mr. Chair, I have one line.
Moved and seconded that the committee adopt a line amendment. As many as favor that motion will say aye. Aye. Those opposed, no. The amendment is before us. All right, so Delegate Hernandez, speaking just to the amendment now, because we already heard the bill last week and we know what it does. You can just remind us briefly what it does and then tell us what the amendment does.
So in a single sentence, this bill, Mr. Chair, seeks to prevent financial discrimination against tenants who have UDs that were dismissed or voluntarily non-suited or otherwise eligible for automatic expungement. What this line amendment that we have included today, all it does is exempt small landlords.
Gotcha. And that's that standard 1 to 4 family, less than 10% of whatever language that we use. All right. All right. Does everybody understand what this bill does? So it says that we apply that rule, but
move to report as amended.
All right, so moved and seconded the report as amended. Clerk will open the roll. The clerk will close the roll. Bill reports by a vote of 5 to 3. Sorry to keep you waiting here so long.
Thank you, Mr. Chair.
Delegate Leftwich, are you here for a bill?
Yes, sir.
Come forward. If anybody else is here, move towards the center. And I'll be Oates, you're here. All right, I see you next.
Okay.
Make sure I'm not saying we do the folks that are not on the committee first. So Delegate Leftwich.
Thank you, Chair Simon. This is House Bill 2577, and I have an amendment in the nature of a substitute. I'd like the clerk to report.
It's been moved and seconded that the subcommittee adopt the committee substitute. As many as favor that motion will say aye.
Aye.
Those opposed, no. The substitute is before us. Delegate Leftwich.
Thank you again, Chair Simon. The substitute essentially turns this bill into a Section 1 bill. I know many times when committees commit Section 1 bills are like, okay, what are you really trying to do with a bill that doesn't really do much? And so let me explain. The city attorney's office for the city of Chesapeake and the council had asked me to introduce some legislation that dealt with localities' ability to deal with unsafe boarded structures, which I think every locality probably struggles with at some point in time. And so they drafted legislation, or we worked together in drafting legislation, which is a result of what the introduced bill did. And as I reviewed that bill, and I tried to work through it in my own mind with regard to provisions of notice, non-conforming uses, and other nuances of that procedure, it became apparent to me that trying to do that without taking into consideration all the other procedures that have been enacted by the VAC to address building codes and things of that nature, I was going down a very, very deep rabbit hole. So ultimately, what I decided to do, and I recommended to my I want to say client, because I'm an attorney, my constituent, was that, hey, let's have the professionals look at this and see if they can make any recommendations on how we can make the procedure in dealing with unsafe structures more streamlined, a more definite procedure. And so that is the result of the Section 1 bill that's before you. And essentially it asked them to review that process during the 2024 building code review process. So it may be something that they might do already, but at least it draws attention to a specific need that I think all localities struggle with.
Gotcha. Have you talked to anybody at DHCD, or we have any feedback on whether they think they have the capacity to do this or not? Because I know.
So initially, brief story. Delegate Arnold and I were sitting around last night, and he goes, "Oh, administration opposes your bill." I'm like, I didn't know that. Would have been nice to know that. So this morning I got on the horn, no pun intended, and texted Brian Horn and let him know that I had a substitute. And from my understanding, they are all good with it.
All good with it. All right. All right. Is there anybody here wishing to speak in favor of any questions from members of the subcommittee? Anyone here wishing to speak in favor of the bill? All right. Anyone here wishing to speak in opposition to the bill? Delegate Webster, I think your bill's less problematic. I mean, we know you were chairman of this full committee, and we do strive hard not to legislate the building code. It doesn't necessarily mean, like we said, we can't direct folks to study the building code so that they can use their process to address some of the concerns we have, which I think is what your bill tries to do. We have so far been, rather than putting these things into law or the acts of assembly to make them do it, we've been generally doing these things with a letter so that we don't overburden these agencies. A lot of these fiscal impact statements we've gotten have said no particular, this is absorbable as this bill, but given the volume of bills, it may not be absorbable as a study we can do. And so to maintain sort of the flexibility of the agencies we're tasking, we don't want to necessarily give it the force of law. And so I think what we've been mostly doing is laying these on the table with a letter. And so I think probably you guys can do what we want, but I think a letter to the Department of HCD asking them to look at these issues in their next building code review might be the best outcome you could hope for.
That's a step in the right direction.
All right. Can I get a motion to do that?
So moved.
Second.
All right. The motion is to lay the bill gently on the table, and we'll send a letter to DHCD and ask them to include this issue in their next building code review. Clerk will open the roll. Clerk will close the roll. Bill is laid on the table by a vote of 6-2. Thank you. All right. Delegate Austin, I understand. I'm sorry, Delegate Oates. You're kind of almost on the committee. Delegate Austin, I know you've got a witness who needs to get going. So do you want to? You're fine?
I'm fine. Yeah.
Okay.
I'm sorry, Delegate Austin, for jumping in front of you.
All right, Delegate Oates, you've got a bill, and I think Delegate Coiner has a bill. I guess you guys have decided that you're going to be your bill should be the vehicle.
That's correct. Thank you, Chairman.
Can we get a bill to incorporate House Bill, a motion to roll 2292 into 2750? Those in favor of that motion will say aye. Aye. Those opposed, no. All right, 2292 is incorporated into 2750. 2750, Delegate Oates, please present your bill.
Yes, sir. Senate, listen to me. Oh my gosh, House Bill 2750. What this bill essentially does is during the 2023 session, this body considered and adopted legislation under House Bill 1519 that would address automatic renewal terms in agreements between common interest community associations and community management firms. That legislation provides that if the management contract contains an automatic renewal provision, the contract must also contain a provision to allow termination without clause on not less than 60 days' notice. The goal of the legislation was to strike a balance in contracts between management firms and volunteer-led communities that may not always understand or appreciate the calendar automatic renewal terms. The change in 2023 was supported by management firms and community associations. In fact, the language of the 2023 bill was a solution proposed by the management firms. The change in 2023 was intended to provide that cancellation would be without penalty. Some management companies, not all, have continued to apply a penalty when an association terminates without cause. This was not what was intended with the bill. So House Bill 2750 should hopefully fix unintended consequences, and it amends the Condominium Act and Property Owners Association Act to make clear that without cause, termination of a management contract means that the termination is without penalty. It also requires community management firms to transfer and release all association funds and close association bank accounts within a reasonable time after termination of the management agreement. This requirement is consistent with current requirements for release of association books and records by management firms. And thank you all. I appreciate it.
Your knowledge of association and HOA law is very, very impressive. That was a very thorough explanation. It looks like you also may have a phone a friend who could help if we have questions. Anybody on the subcommittee have any questions for Delegate Oates? All right. Anyone wishing to speak in favor of the bill? Mr. Gianni.
Thank you, Delegate Oates. Thank you, Delegate Oates, and also thank you to Delegate Coiner for bringing the bill. It's an important change to make clear that cancellation without cause also means without penalty. It's been paramutated by some companies, not all, as the delegate properly described, so it's a great change, and also allows for the release of funds in a timely manner when a contract is terminated. So strongly support the bill. Thank you.
Thank you. All right. Anyone wishing to speak in opposition to the bill? All right. Seeing none, it sounds like it's something that the association and the management folks want.
Chair, move to report.
Move to report. Is there a second?
Second.
All right. It's moved and seconded to the bill report. The clerk will open the roll. The clerk will close the roll. Bill report 6-1.
Thank you very much, Chair and Committee.
With substitute, right. Reported with substitute. All right, Delegate Carr, you've got, let's see, I'm sorry, we have Delegate Austin first. Delegate Austin, let's do, I'm sorry. Delegate Cordoza. Trying to run through patrons, it's getting a little confused. Delegate Cordoza.
How you doing, Mr. Chair?
Delegate Cordoza, House Bill 2589.
All right, House Bill 2589 allows a nonprofit organization to be granted a tax-exempt status as a 501c3 to provide stickers to be distributed with ABC licenses in for rest stop bathrooms and high traffic areas along highways to provide information about human trafficking. And I have with me someone who can explain in more detail about the bill, if that's a pleasure to chair.
Yep, go ahead.
Thank you, Delegate. My name is Anna Glider, and I'm the founder of the Anchor Project. We are a nonprofit organization. The awareness sticker initiative from the Anchor Project would be able to display these stickers and go out with every liquor license, retail license, and rest stop restrooms. As you know, human trafficking is a big issue in the state of Virginia, and we as a nonprofit and many others are very concerned about it. A study was conducted in 2016 by Northern University in Boston states that displaying National Human Trafficking Hotline in public places brings out more arrests as well as awareness for the public.
I'm so sorry to interrupt, but I see the confused faces. There's a substitute, and if someone could move that, it would be properly before you.
All right, there's been a motion properly seconded to adopt the substitutes. May favor of that motion will say aye. Those opposed, no. All right, the motion is agreed to. The substitute is before us. Continue, I'm sorry.
Apologies. 2 bills have already passed in the state of Oregon in 2016 and 2017, which are almost a replica to what we bring to you here, that a nonprofit organization will supply these stickers to go out with every liquor license as well as to rest stop restrooms. I hope you consider this bill. I can answer any questions.
All right, hold on one second. I'm going to get the substitute to come up. Is there any questions from members of the subcommittee? Delegate Price.
Yes, Mr. Chair, can we have council describe the differences within the substitute from the introduced version? Please.
Ms. Benz.
Mr. Chairman.
Yes.
Delegate Price. I'm going to be completely honest with you. I was not the drafter on this, and I think that the language came mostly from the stakeholders, so she may be the better
Mr.
one
Chair.
to explain all of the differences.
May I redirect my question?
Yeah, Delegate Price. Go ahead.
To the patron or the witness, can you describe the differences between the introduced version and the substitute we now have before us? It just looks very much alike.
They gave you the wrong thing and you said, what do you make them change?
What was presented to me is that there is information currently at rest stops with the National Human Trafficking Hotline. I would like for the stickers to be in restrooms, in bathroom stalls and restrooms and rest stops, as well as we currently don't have any kind of National Human Trafficking Hotline go out with any liquor license or retail license.
All right. Delegate Price.
I'm so sorry. Maybe please go back to council in case there's anything additional to add.
Apologies, Mr. Chair, Delegate Price. So I believe that the main difference between the introduced version and this version is language added dealing with the, what's the name of it? The Sex Trafficking Response Coordinator. So that section that is added starting on line 58, also on line 31, those two code sections were added to create a duty for the coordinator to review the materials that are supposed to be provided to the ABC and Department of Transportation under this bill to kind of vet those materials that come from the nonprofit.
All right, so this says that a nonprofit organization that's been granted tax exempt status can do this. What if there are, 6 or 7 or 8 nonprofits and they all submit stickers? Do you have to post every organization's stickers in all the same places and sort of just plaster the door with the stickers?
So that, of course, up to the vetting authority will pick which sticker is the one that's used.
Yeah, I appreciate that response. And again, this is one of the problems. It says that if the nonprofit supplies them, then the authority shall post them, and it uses fairly prescriptive language. The only reason not to post it, as I read the bill, is I'm just reading it now, would be as if the contents were deemed to be offensive in some way, or if the information, I guess, and we're putting the authority in the position of deciding whether the information provided is objectively. What's the word? There's a term for it. Objectively true or something like that. So I understand what you're trying to do. I don't know that this is the kind of a thing that it lends itself to this kind of legislation. Also not sure what the penalties are for noncompliance. So anyway, those are some of my questions about the bill. Any other questions from members of the subcommittee?
Mr. Chair.
Delegate Carr.
I have a motion in light of the confusion, and it seems like maybe this is not quite ready for prime time. I move that we pass it by for the day.
All right. It's been moved. Is there anyone wishing to speak in opposition to the bill before we do that? Anyone else wishing to speak in favor of the bill?
We do have those.
All right. If you guys are here to speak in favor, come forward. Go ahead. Identify yourself and please tell us.
Thank you, Mr. Simon. My name is Ms. Haley Shoopdollar. I'm an Army combat veteran. I am a graduate of 4 separate college degrees. I am a resident of Virginia, and I am a survivor of human trafficking. I grew up in between Yorktown and Newport News, Virginia. I've also worked in Richmond and all over the state. both as a federal contract employee and as a civilian. And I can tell you that right now, with the waves of human trafficking that are coming upon our great state, those of which that I have experienced personally, this bill is necessary to protect women and children and also men that find themselves trapped within this industry with no way to get out. It may seem that there is some confusion as to how we're going to adhere these policies and what's going on here and there, but I can tell you that people would benefit. Our people, our constituents, and even those from out of state that are here against their will can and will benefit from having phone numbers posted. And it doesn't matter which agency that it comes from, as long as it is viable information that is vetted through our federal government that can help these survivors who are currently victims of being trafficked, going through the worst instances of their lives. And I can tell you right now, next to substance abuse, the recovery rate for women like me to even be able to pursue a college degree, to be able to even serve in the military is very low because most of us do not survive. So to post a phone number in a public rest stop, to give them that opportunity to come forward, because I can tell you it takes at least 3 to 5 times before a victim of domestic violence or of human trafficking will even consider coming forward. This is a complex issue, and there are many simple solutions to combat this. And if we don't begin to combat this at the lowest level, something as simple as putting stickers out and issuing something to these companies that have these ABC licenses, because let's face it, I've lived this life. I know many people have not. But it is happening in any establishment and everywhere that serves liquor. It's a great environment for it. So if we can have this signage, this postage, these stickers, you will end up saving more women and children than you realize. And I am a testament to that. I am a living testament of the fact that with proper resource referrals, with a foundation in our community that cares, you can not only just survive, but you can recover and you can thrive. So, I am in support of this bill. I believe that if you are not, there may be some other underlying issues there. However, in conjunction with Anna Glider, with the Anchor Project, who I have learned so much from, and in such my ability and my and even being able to publicly speak as a survivor. There are not many women like me that are willing to come up to the bat and come up to this podium and approach people like you and share the dirty, the nitty-gritty, the things that we have been through. We would rather live in shame than to come and stand forward and to speak about things as something as simple as a sticker. But I can tell you, it doesn't matter what nonprofit it comes from. It doesn't matter where it comes from. As long as that information is valid and vetted and it can help survivors, then it will. And I think, Mr. Simon, thank you so much, that this bill will provide so much good to our state, especially with the oncoming waves of human trafficking, that we will never be able to stop completely. But what we can do with these stickers, what we can do with this collaboration with any business that has an ABC liquor license, we can at least save some women, men, and children from being trafficked.
Thank you.
You're very welcome.
Thank you very much.
Thank you so much for your time, everyone.
Thank you.
Thanks for your story.
Check, check. Peace and blessings, everybody. My name is Jafari Jones. I'm the president of BLM 757, also known as Black Lives Matter 757. People often know us as an organization that is strictly for police reform, but we also conduct search and rescue missions. Approximately 4 years ago, we were able to search and rescue a missing 14-year-old who was being housed and could have potentially been trafficked by an individual much older than she was. We were able to get her back to her family safely. We feel like that this bill will be productive to the entire integrity of Virginia and those beyond, because as we all know, Virginia is the housing of many different ports and many different colleges and universities. and we have many different walks of life. And so we would, definitely agree that this bill would be something that would be beneficial. It's something that's very cost efficient because something as simple as a sticker is not very cost efficient, so it wouldn't dig too deeply into the state's budget. And we were even willing to volunteer our own services that if the budget is to exceed what the state's allowed or allotted, that we will produce the stickers ourselves and go throughout the state if provided a map to do so. We also like to inform everybody of, like I said, our social media. We have over 500,000 different followers, and it is election season. And something so critical as this, we would hope that it would fall on nonpartisan ears. We would hope that we would be able to save multiple different individuals who are maybe exposed to human trafficking. We were able to get the Code Alert passed for missing children here in the state of Virginia, and already since September it has already saved 7 lives and brought 7 children home safely. And so we like to be able to work across party lines, Democratic, Republican, Libertarian, and Independent, to make sure that we are ensuring that Virginia as a whole is a safe place. And if somebody is being trafficked in something so small as a sticker at a rest stop, where we know that if you're traveling throughout the state, trying to make your way across state lines, that you can see the sticker if you have access to a cell phone, whether it be through memory or taking a picture with their own cell phone to be able to reach out. We feel like this bill would be something that shouldn't be hard to agree on. And, with that being said, we'd like to say we speak highly in favor of this bill, and we hope that we can pass a resolution to make this move forward.
Thank you.
Good evening, everyone. My name is Portnoy Evans Johnson. I support wholeheartedly House Bill 2589. I think it's amazing that they've come up with an idea to print out stickers. I was looking at the information on my smartphone from the National Labor Trafficking Hotline, and it says currently there is over a 15-minute wait. It's a problem that I don't think we recognize the proportions of it. Labor trafficking, people don't even understand what that looks like. I heartily support this bill.
Thank you. All right. Anyone wishing to speak in opposition to the bill? All right. We have some folks in the queue that would be recognized. Delegate Bennett Parker.
Thank you, Mr. Chair. First, I really want to thank the witnesses for their testimony and sharing their lived experience. I don't take that lightly, and for the work that you're doing to help others and end human trafficking. I really appreciate that. I used to work for a nonprofit that also worked with some survivors of trafficking, and so under this bill, my former organization would be able to send materials to ABC, and if approved by the coordinator, then ABC would have to send that information to every on-premise retail licensee in Virginia. And the same would be true for any 501c3 nonprofit. And we're fortunate to have a lot of nonprofits like yours, both here in Virginia and across the country working on this issue. I don't think the bill language, it isn't limited to stickers. It allows stickers. It says all materials that are sent have to be posted if approved. And it makes no reference to the hotline. So I think one of my concerns is that I'm not sure I think it would be confusing to send info from a nonprofit like Samaritan House that is working to provide resources to victims in Southeast Virginia, and to send that material and require that it be posted in restaurants in my district in Alexandria, Virginia. So I know that we have a lot of bills this session to address human trafficking, including one that will develop a training for retail licensee employees, so for those restaurant employees on how to recognize and report human trafficking. And so I think that's probably a better way to accomplish this goal given the issues with this language as it is before us. Thank you, Mr. Chair.
Thank you, Delegate Bennett Parker. Thank you, Delegate Bennett Parker. Delegate Price.
Yes, thank you. And I also want to thank you for coming forward. When we have ideas that come from real life experience, I'm sorry, Mr. Chair, speaking to the bill.
Delegate Price.
When we have organizations that are doing good work and have an idea, it is incumbent upon the legislator to go through the process for the language to be appropriate once it gets to committee. And so I believe that you all have wholeheartedly described an idea that sounds workable, but that's not what we're voting on. What we are voting on right now is the language that's in front of us that really has some significant problems for workability. And so I would appreciate, even if, like, as you're describing, as your testimony is describing, that it be the specific hotline that is getting so many calls that it has a 15-minute wait. That's not what's in front of us. So that's not actually what we're voting on, and it's the legislator's job to take take an idea from the community and get it ready for today. And I just do not believe that that's what's happened. And so I appreciate what the story is, but until the language matches the idea as has been described, we're having two different conversations. And so I don't want there to be misunderstanding. So if there is time to work on the language to get it to match as was described, as simple of an idea as you have described, but unfortunately, as written in front of us, this is chaos. And this would be Hampton Roads information going out to Bristol, Virginia. And that's chaotic, and it's not helpful for what it is you're trying to accomplish. So if there were a way for us to get the language right, to get it as tight and as simple as was described, I would definitely support that. But again, that's not what's in front of us at this moment.
All right. All right, so Delegate Card moved that we take the bill by for the day. Is there a second?
Second.
All right, as many as heard that motion will say aye.
Aye.
Those opposed, no. All right, the bill's taken by for the day. Thank you, Delegate Cordoza. Thank you,
Thank you,
everyone.
Mr. Chair.
Delegate Cole is not here. All right, so we've got Delegate Austin.
Thank you, Mr. Chairman, members of the committee. Before you today, I have HB 2642, counterfeit lighters. Mr. Chair, HB 4622 addresses consumer safety concerns by regulating and prohibiting the sale of unsafe and counterfeit lighters in the Commonwealth. The bill creates definitions for lighters, unsafe lighters, and counterfeit lighters to protect consumers from hazardous products. In 2017 alone, more than 300 million lighters were imported from China and other countries. 70% of those lighters failed to meet safety standards requiring child-resistant mechanisms. 2642 regulates the sale of lighters by defining unsafe lighters as those who fail to meet the American Society for Testing and Materials, ASTM International Standards F400-20, and specifies consumer safety standards, and defining a counterfeit lighter as any device which infringes upon intellectual property of the United States citizens and entities protected under the federal and state intellectual properties. Similar legislation has been passed in Wisconsin and Connecticut. So, Mr. Chairman, that's the bill before you.
All right. Any questions from members of the subcommittee about this bill? So this bill makes it a violation of the Fire Prevention Code, but and I understand, and Delegate Austin, correct me if I'm wrong, as I understand, the only way this gets enforced, in other words, this isn't going to result in Fire Prevention Code officers going out and inspecting lighters or anything like that, but they'd have the authority in the event of a complaint to go in and then inform a retailer or somebody that they're dealing with a potentially dangerous item. Is that accurate?
That they're not meeting the ASTM standards.
ASTM standards. All right. Anyone wishing to speak in favor of the bill, please come forward.
Good morning, Mr. Chairman, members of the subcommittee. David Skiles with the Vector Corporation representing BIC, and we appreciate Delegate Austin igniting this conversation on lighter safety. Oh, there you go.
Lost 2 votes.
I'll try and get them back. As the patron explained, there is a serious issue with the proliferation of counterfeit and unsafe lighters. As we have seen over the past few years, there has been an influx or inundation into the market by lighters from China. Most of those lighters do not maintain safety mechanisms or child safety mechanisms. And so what this bill does, is as the patron explained, is provide a code, a definition in the code for what is a counterfeit or an unsafe lighter is, and then provides an enforcement mechanism if those lighters are to be found being sold. Importantly, this legislation does not impact or impede interstate commerce. Lighters that are unsafe or counterfeit lighters could be stored in a warehouse and transported out of state, as long as that warehouse is not a point of retail sale, but they cannot obviously be transported or sold at a retail sale here in the Commonwealth. And just to further note, while BIC is obviously the lighter of choice for many, including me on the golf course, other U.S. companies are Zip, Cricket, Scripto, Calico, and Beacon, all of which meet the ASTM standard. So, Mr. Chairman, I'll conclude my comments and happy to answer any questions.
All right. Any questions for Mr. Skiles? All right. Anyone else wishing to speak in favor of the bill?
Mr. Chairman, members of the committee, Stephen Seitz representing the Virginia Fire Prevention Association, which represents fire marshals and code enforcement people across the Commonwealth. And obviously, we're going to support this bill for the safety of all the citizens of the Commonwealth from fire hazards and injuries due to these lighters. Thank you, sir.
All right. Anyone else wishing to speak in favor of the bill? Anybody wishing to speak in opposition to the bill? Please come forward. So, hold on, give me, Pete, I just want to look at this for one second. Are we actually, I think I heard somebody make this comment, are we legislating the fire code, or is this something other than that? Mr. Skiles.
Mr. Chairman, I would note we had a conversation a few bills ago regarding fireworks. We already define different types of devices in the code in Chapter 27 to include permissible fireworks. Had this committee acted differently, and I'm glad they didn't, on Delegate Garrett's bill, you would have defined consumer fireworks. So the code already contains definitions such as that for permissible fireworks. I would view this very similar to what the existing statute does with those types of devices.
Well, again, question again. So the last couple lines of this say the fire prevention code shall prohibit. So we're not legislating the fire code and that we're not writing language in the fire code, but we're basically telling. So how's that piece, that on line 107, going to be executed? I mean, this is a genuine question. I'm not trying to trip anybody up.
Yeah,
so it
Mr.
says
Chair,
the fire prevention code shall prohibit the offering of the sale to the public of unsafe lighters or counterfeit lighters, but it won't prohibit the interstate transportation of counterfeit lighters or unsafe lighters. So we're saying in the code that that's what it's got to say. So what's the process for this piece coming to be? Like the fire code, next time they go through, they're going to say, well, there's a new code section, so we've got to update it.
So violating the fire code, as you know, Mr. Chairman, violation of the fire code right now is a Class 1 misdemeanor. What I would submit is in other states that have done this or similar action with respect to unsafe lighters, that is typically done through the fire code. I recognize the Commonwealth is the Commonwealth, we're not some other state. But the net impact, or how the enforcement mechanism, if someone were to, as the patron noted, if someone were to get a phone call and a fire marshal or fire official were to inspect the facility and see that unsafe lighters were being sold or available for retail sale, the fire or the inspector would raise that issue with the retailer. And I'm certain that as all of our fire folks are accommodating or reasonable, that they would raise that before they imposed a fine.
Got it. So actually, it's sort of like, and I'm looking at the bill, line 72 of the bill says this fire prevention code shall prohibit transportation and storing of the fireworks. And so this is similar language on line 107 to what we see up there about fireworks. We're sort of putting these illegal lighters into the same category, it sounds like.
Mr. Chairman, given my extensive time spent on fireworks over the past few years, I thought what better way to do this than to replicate it.
Got it. Understood. All right. Any other questions from members of the subcommittee? All right. Seeing none. Anybody wishing to speak? We already asked for pros and cons. All right. Any committee operates by motion. All right. It's been moved and seconded. The bill report. Clerk will open the roll. I guess. All right. Clerk will close the roll. Bill reports 8-0. So the most reluctant unanimous vote I've ever seen. But there we go. All right. Who's left? Delegate Cole is not going to be able to make it back, I don't think, and he asked that if we couldn't do that we lay his bill on the table, and then potentially we can see about sending it somewhere, but for the time being, let's lay that bill on the table. So it's been moved and seconded that we lay House Bill 1943 on the table. Has been in favor of that motion? Oh, clerk, it's been moved and properly seconded. So the clerk will open the roll. Oh, you want to do that? All right. You know what? The clerk will destroy the roll. And I hear is a substitute motion to go by for the day? Yes. All right.
Second.
All right. As many as favor of that motion will say aye. Aye. Those opposed? All right. The motion carries. 1943 is by for the day. All right. Delegate Bennett Parker, House Bill 1973.
Thank you, Mr. Chair. I have a substitute.
Move this. Substitute. So moved and seconded that we adopt the committee substitutes. May favor of that motion will say aye. Aye. Those opposed? All right. The substitute's before us.
Thank you, Mr. Chair. House Bill 1973 adds a tool in the toolbox to help us address Virginia's affordable housing crisis and keep our existing affordable housing inventory. This bill addresses rental buildings that have received state or federal assistance to create affordable units, for example, through the Low Income Housing Tax Credit or LIHTC program. When those affordability restrictions are expiring, after 30 years for LIHTC, for example, and the owner intends to sell the building, the bill would allow localities to establish a right of first refusal if and only if they can match a third-party offer. The owner receives the same purchase price and the housing remains affordable. The locality cannot provide a matching offer, the owner sells to a third party. These are buildings that have already received public assistance from taxpayers, so this is a simple way to make sure that our state and federal investments in affordable housing continue to benefit Virginians. Preservation also saves money going forward. It costs 25 to 40% more to develop a unit of affordable rental housing through new construction than through the acquisition and rehabilitation of existing housing units. Preservation also prevents tenant displacement and its negative consequences on people and communities. We've made a number of changes to the bill from last year's version, not only to streamline and simplify it, but also to address concerns that a locality cannot play favorites with this process. More than 7,000 publicly supported affordable rental units are at risk of losing their affordability in the next 5 years, and that number quadruples to almost 30,000 in the next 10 years. We have an affordable housing crisis with these units, and we cannot afford to lose them. Thank you, Mr. Chair.
All right. Any questions for the patron? All right. Anyone here wishing to speak in favor of the bill, please come forward. And this is a bill, by the way, that is very, very similar to a bill that we passed last year, but better, new and improved?
Yes, new and improved.
All right, go ahead.
Thank you, Mr. Chairman. Troy Garrett, the Executive Director for the Virginia Association of Housing and Community Development Officials, and we support this bill.
Thank you. That's excellent testimony. Good example for all your peers.
Hi, Mr. Chair, members of the subcommittee, Christy Mayer of Virginia Poverty Law Center. We also support the bill.
Hello, Mr. Chair, members of the committee. Gustavo Espinosa, community organizer with the Legal Aid Justice Center and the Allies for Housing Action. As a community organizer, I have knocked on hundreds of doors in many low-income communities where the subsidies are expiring last year, this year, 2026, 2028. These are going to expire before their kids graduate from school. People are worried about what will happen to their families when the protections fall out from under them. The rent can be jacked up. The whole property can be flipped. People's leases can be non-renewed with no reason. We're talking about mass displacement. Please support this bill. Thank you.
Thank you.
Sheila with the Virginia Interfaith Center for Public Policy. We support the bill and associate our comments.
Thank you, and that's excellent.
Stuart Schwartz, Coalition for Smarter Growth. We support the bill. Thank you.
Thank you, Mr. Schwartz. Good to see you. All right. Anybody really want to speak against this bill? All right, come on. No, that's not what I meant to say. I meant anyone wishing to speak in opposition to the bill, please come forward.
Mr. Chair, members of the committee, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We do have to respectfully oppose the bill. We don't support right of first refusal as a concept. It discourages investment. Buyers and lenders avoid markets with unpredictable risks, and so that ultimately does drive up costs for renters, and it does delay the process significantly. So for that reason, we do oppose the bill. Thank you.
Thank you. All right. Anyone else wishing to speak in opposition to the bill? All right. Any further questions from the subcommittee? You've got one. Oh, one more remote. Isabel wants to tell us that she loves this bill. Ms. McLean.
Thank you, Mr. Chair, for the chance to say that I love this bill. Isabel McLean with the Virginia Housing Alliance. And yes, we support this bill and are really grateful for the patron for bringing it. Thank you.
Thank you. All right. With that, committee operates by motion.
Move to report. Second.
It's been moved and seconded with bill report with substitute. Clerk will open the roll. Clerk will close the roll. Bill reports by a vote of 5-3. Thank you, Delegate Bennett Parker. All right, Delegate Carr, you've got two bills.
Yes, sir.
I think these are the last two to be heard. So if
All
you're
right.
waiting for the next subcommittee, we should be done in about 20 or 30 minutes.
I'll try to be
I got some more groans than laughs, sorry. Delegate Carr.
Thank you, Mr. Chair. Moving along with housing bills and toolboxes for the localities. I'm looking at 2153, our faith in housing.
You have a substitute for that?
Yes, I do.
Move the substitute.
It's been moved and seconded that the subcommittee adopt a substitute. As many as favor of that motion will say aye.
Aye.
Those opposed, the substitute is before us. Delegate Carr.
Thank you, Mr. Chair. HB 2153 enables localities to pass ordinances to simplify the process for property tax exempt nonprofits, including faith communities, to build multifamily affordable housing on their land. The bill also asks localities to incorporate strategies in comprehensive plans that would support property tax exempt nonprofits building housing. Finally, it allows the Department of Housing and Community Development to provide potential strategies for both comprehensive plan and ordinances that localities can consider. The bill originated in response to faith organizations who want to respond to the housing crisis in Virginia by putting underutilized land that the congregation owns to use. The bill will create an innovative new tool in the toolbox for localities. The substitute, Mr. Chairman, clarifies language to ensure that this ordinance would apply to all tax-exempt nonprofits, not just to faith organizations. It also greatly streamlines the language for the comprehensive plans and local ordinances so localities can be more prescriptive to their needs.
All right. So the big change in the substitute is that it opens this up to all nonprofit 501c3 organizations that are eligible for tax exempt, they're exempt from paying property taxes and doesn't limit it to just faith-based organizations. All right, are there any questions from the subcommittee? Anyone in the audience wishing to speak in favor of the bill, please come forward.
Good afternoon, Mr. Chair, members of the subcommittee. Sheila Hurley-Hennessy with the Virginia Interfaith Center for Public Policy. This is a major issue because we have an affordable housing crisis in Virginia, a shortage of over 200,000 units, and faith communities are also in crisis as they see declining membership and declining contributions. This is a way that congregations can choose to continue to live their values, and other property tax exempt nonprofits are also eligible to do so by allowing localities to make the process a little bit easier for people who don't do this on the daily basis. More than 14 congregations around Virginia have already built housing, but all of them found the process cumbersome and difficult. And so to make it a little bit easier for the dozens more who are considering doing this kind of process, I would ask that you support this bill. Thank you.
Thank you.
Good afternoon. Thank you for the opportunity to make comments. I'm Roxanne Rucker. Speaking really as a private citizen, what's unique about what I have to say is that I recently moved here from Washington, D.C., where my faith community moved forward with an affordable housing project to build 224 affordable housing units as a way of unlocking the wealth that was in that church property and serve the desperate needs of the community there in Washington, D.C. Now that I'm here, I would love to see more faith communities in Virginia have access also to these creative solutions to address this housing crisis. Thank you.
Thank you.
Hello again, Mr. Chair, members of the committee. Gustavo Espinosa with the Legal Aid Justice Center. And also on behalf of the New Virginia Majority, we would like to thank the patron for her bill and her commitment to this issue. We support and desperately need long-term supply-side solutions, especially creative ones like this one. These solutions are especially helpful when coupled with strong protections for tenants so they can stay in their homes in the short term. So thank you so much.
Thank you.
Thank you, Mr. Chairman. Troy Garrett with the Virginia Association of Housing and Community Development Officials, and we support this bill now.
Thank you. Did you say now? All right.
Thank you, Chairman. Stuart Schwartz, Coalition for Smarter Growth. We've worked with a number of faith nonprofits in Northern Virginia, supporting their projects. So we do support this bill and certainly encourage it for locations close to jobs, transit, and other services. Thank you.
Thank you. I haven't asked for the no's yet.
Ms. Ahmed with the Apartment and Office Building Association and Virginia Apartment Management Association. We support the bill.
Oh,
Thank you.
Thank you. All right. Anyone else wishing to speak in favor of the bill? Anyone wishing to speak in opposition to the bill? Seeing none, the committee operates by motion. So we have a motion properly seconded to report with substitute. Delegate Coiner speaking to the motion.
Mr. Chair, speaking the bill. So I want more affordable housing everywhere, but I think one of the things that struck me by one of the speakers that said, you know, when churches and nonprofits have tried to go through and get zoned for housing, they've realized how difficult it is. It's difficult for everybody who wants to do affordable housing. So if what we really want is affordable housing, rather than the state picking and choosing who gets to do it easily or not, we ought to just let everybody who's willing to meet our definition of affordable housing go do it. So, I was going to offer a friendly amendment to just open it up. We define what we want, and if you're willing to build it, go do it. But I'm not sure why someone in my community who's an expert in housing right now, they could go do it tomorrow. I agree with the process were easier, or a church, or a nonprofit, or anybody else. If our goal is more affordable housing, let's just make that our goal and let's get to it and let everybody make an effort to do it. So that would be my suggestion, Mr. Chair.
Thank you, Delegate Coiner. And I do have a bill that was heard in CC&T this morning, and I think that does streamline a lot of the processes, and we do a lot of things to try and speed things along. And who knows, there's always next year for more bills. So it's been moved and seconded the bill report with substitute. The clerk will open the roll. The clerk will close the roll. Bill reports 6-2. All right, Delegate Carr, you have one more.
Yes, sir. I have 2163, which made a peek through at our last meeting. But this bill, I'd like to move the committee substitute.
Second.
It's been moved and seconded to adopt the committee substitute. As many as fair that motion will say aye. Aye. Those opposed, no. The committee substitute is before us. Delegate Carr.
This legislation makes a few updates to the Enterprise Zone program, which will modernize and enhance it for better economic growth in Virginia's most economically distressed areas. The program has been instrumental in revitalizing neighborhoods and creating jobs, but it hasn't been significantly updated in 20 years. The key changes include in this bill elevated grant tier for larger investments. This would offer higher incentives for investments over $20 million, encouraging large-scale developments with the grant cap increased to $300,000 over 5 years, which would have transformative impact on communities. Support for daycare centers, expanding grant eligibility to include daycare centers, supports working families by increasing workforce participation and fostering a more sustainable economic environment. And a work group to review current zones. This work group would assess the effectiveness of current enterprise zones, ensuring that resources are optimally allocated and that zones receiving support are achieving their intended outcomes. These updates are necessary as we continue to align economic development programs across the Commonwealth. I believe a representative from Virginia Economic Developers Association is here to speak to the legislation as well.
Is that true? All right. Wasn't sure if we wore you out and chased you off. Go ahead.
Elizabeth Rafferty here on behalf of the Economic Developers Association and all the local and regional economic developers there. We're in support of the legislation, and we appreciate Delegate Carr carrying it. If you have any questions, we're happy to answer.
Okay. I think we also have somebody from the Economic Developers Association online. Matt Johnson. Mr. Johnson, do you want to add anything to that?
I'll just add that on behalf of the economic developers across Virginia, we're here to offer support for House Bill 2163. As a practitioner in economic development for over 15 years, I've witnessed firsthand how the Enterprise Zone program can help draw meaningful private investment into distressed communities, creating job opportunities for residents and enabling transformational change. The proposed improvements to the bill will really enhance the potential for distressed areas throughout Virginia benefit from this valuable program, and I'd like to thank Delegate Carr for carrying the bill and respectfully ask the committee to act favorably on the bill, allowing it to be moved forward. Thank you.
All right. And I guess since we're on this mode, why don't we go ahead? Anybody else here wishing to speak in favor of the bill, please come forward.
Yes, Mr. Chairman, Laura Bateman with Virginia First Cities Coalition, and we are very supportive of the bill and thank the patron for bringing it forward. Thank you.
All right. Anybody wishing to speak in opposition to the bill? All right. Any members of the subcommittee have questions for Delegate Carr, comments about the bill? All right, it's been moved and seconded that the bill report with substitute. The clerk will open the roll. The clerk will close the roll. Delegate Parker, do you want to vote? The clerk will close the roll. Bill reports by a vote of 8-0. With nothing further to go on this last meeting of the Housing Subcommittee before crossover, I will almost ready to adjourn. I do want to What do I need to do?
Just announce the next meeting will start at 4:25.
Okay, so our next meeting, which is coming up, will start at 4:25 because it's going to take them a few minutes to take all the technology down and set up the new technology and redo the seats and everything. So if you're here for the next meeting, it'll start about 4:25. I do want to give a real big appreciation again to our DLS staff, particularly Ashley Binns and Rose Cropper. And I know we'll see them again next week after crossover, but this has been the hard part. I think we're over the hump. So with that, the committee will rise.
Thank you, Mr. Chair.